What's up? Welcome to another edition of Off the Dome with attorney Issa Israel, and today we're going to be discussing the lawsuit between Cardi B and Tasha Kay. As usual, feel free to use this material for anything that complies with fair use. You can also contact me if you need legal help or want to discuss anything, business, whatever the case may be, at help@iilawfirm.com. I practice in Colorado with respect to most legal issues, but there are some matters that are federal in nature, in which case I can represent individuals in those areas as well. So Cardi B is a Grammy award-winning rapper. Tasha Kay is a YouTube personality. She has a very successful channel, and she's the producer and host of a show called Unwind with Tasha Kay. As you can see from the first page of this complaint, there's a couple things that stand out. This is a federal suit. Basically, parties are allowed to go to federal court if the claims present distinct federal issues. Another avenue is if there's diversity between the parties. So let's say one party lives in Atlanta, the other party lives in New York. Then you can take the federal route as long as the dispute involves an amount of a significant number. I think way back when I was in law school, I think it was 500,000, ended up going up to 750,000. I don't do much work in federal, in terms of federal suits. Most of my actions are state. I think of one big exception to that right now, but yeah, I mean, I would say that's the case with most attorneys, and then there are certainly attorneys and firms that focus on federal matters. Cardi B, her actual name is Belsares Marlinas Almanzar, and Tasha Kay is Latasha Transrena Kebi. And also Latasha Transrena Howard. I'm not sure. I would imagine one is her maiden name and one is her married name. But anyway, she's the defendant along with her company, Kebi Studios LLC. As you can see, this is a second amended complaint. A lot of times you'll initially file a complaint, more information or facts come to light, and then you make changes to the lawsuit and thereby amend it. Okay. Now, we're not going to really go through page by page because it's a lot of pages to go here, but that's the parties. The problem is this. So Cardi B is alleging, or certainly already alleged, because at this point there has been a judgment, but Cardi B is alleging that Tasha Kay defamed her. How did she defame her? Well, she said that she's a prostitute, that she prostitutes herself. She accused her of adultery. She accused her of having herpes and HPV. She's accused her of engaging in lewd sexual acts with a bottle, and a lot more. So, really, really offensive, wild accusations. That's not to get into whether or not they're true or not, but certainly they're offensive. Whether or not she made those accusations aren't that was never really in dispute because of course Tasha Kay has a YouTube channel, so the things that she said, it's there for public consumption. Questions that are probably important in a matter like this is the most important issue here is always going to be truth. Whenever it comes down to a defamation action, a lawsuit for defamation, the number one defense is, hey, what I said was true. Now, there are certainly other factors that come into play, so if it wasn't true, well, was it substantially true, or kind of like, was it reasonable to conclude that based on XYZ? Was there malice involved even, and that's particularly true when we're dealing with public figures and public officials and what have you. A lot of times what it is that the thinking is, well, listen, if you're famous or if you took this position that puts you in the eyes of the public, well, now you opened yourself up to additional scrutiny. So from a constitutional perspective, people ought to be free to talk and have, free and robust debate, as they say, on a number of different issues, especially things that are in that public domain. So what the law does then to try to make it even or make it fair is, okay, well, listen, if you voluntarily put yourself in the position to be scrutinized, then we're going to require a bit more in causes of action such as defamation. We may require you to show that what this person said about you, it wasn't just a terrible thing, it wasn't just false, but we're going to require you to show that they knew that it was false, or that they more or less didn't give a damn whether or not it was false or not. So freedom of speech is always implicated in these sorts of cases. There's 7 causes of action here. 5 are particularly relevant. I say the other 2 aren't really relevant because one is just a claim for punitive damages and attorney fees. A lot of times in lawsuits, well, virtually all the time in lawsuits, attorney fees are sought. Punitive damages, it's a particular kind of damage, just basically means the kind of damages that a party would seek in order to punish the other party, right? So there's a lot of different ways to look at damages. So in defamation cases, a lot of times, and in particular if there's public officials or public figures, the court is going to look at or be interested in what the actual damages were. And then they might want to look at things like punitive damages. So in addition to what this person suffered, we're going to punish the wrongdoer as well. So we're going to award actual damages or compensatory damages, and then we're also going to award punitive damages just to crack them on the head here. But let's get to it. Defamation. What the heck is defamation? So defamation is a cause of action in which you inflict harm or in which you inflict harm or damage to someone's reputation. Okay. In terms of the elements of defamation, it always involves a false statement of fact. So again, if what they're saying is true, you don't have a case for defamation. So it involves a false statement of fact. It has to be published or communicated. There has to be fault at least at the level of negligence, and then you have to have damages or harm. Now with civil lawsuits, I mean, a lot of times I see people talk about suing people, but the reality is if you want to have a successful lawsuit, you always have to have damages. There's some special causes of action where that doesn't apply, but in general, if you want to sue someone, you've got to have damages, right? So someone breaches a contract and there's not a clause in there, for example, agreeing to liquidated damages, and let's say as a result of the breach, it really only cost you, $200. Well, you don't really have then the basis to file a lawsuit for $100,000, so you've got to have damages. And if you don't even have the $200 because of some other reason, then you don't have damages at all, and your lawsuit is not going to stand. So that's the damages. Now the fault, and I'm going in reverse order here, but the fault, at least at the level of negligence, just means that, again, with this statement being false, it's not enough to make a false statement. You've got to show that it's essentially your fault that you made the false statement. So let's say, for example, if I told you something about me and then you published it and it was negative and it caused me harm, well, the issue of whether or not there's fault is going to be highly disputed because after all, you got the information from me to begin with, right? So anyway, there's the fault. Now that fault threshold is going to change or fluctuate based on what kind of plaintiff we're looking at, as I indicated earlier, right? So if it's a public figure, public official, that sort of thing, well, the courts will generally require more fault. So instead of just negligence, they want to show, that you had actual knowledge, right, or you completely or reckless disregard for the truth or falsity, right? So you didn't care whether it's true or not. You just wanted to say it anyway. Now this second element about publication or communication. So basically, the false statement, right? It has to be actually communicated to somebody else. So again, in that scenario that I offered, if I say something negative about my own self to you, and let's say you repeat it back to me, you throw it up in my face in a personal argument, I can't sue you for defamation because you haven't published it or communicated it to a third party. You just said it to me. So I can't sue you for saying negative, false things to me, at least not for defamation, right? And I certainly can't sue you if you say it to yourself. Now, if you say it to yourself and you record it and you publish it online, well, now you've now published it, right, to a third party. You've published it to the general public. And the first element and most important, that false statement of fact. Now, so there's a couple things to read in there. The statement has to be false, and it has to be one of fact. So it can't be an opinion. It has to be a fact, right? Or it has to be purported to be a fact, you know? So you can't say, hey, listen, I don't think Issa's a nice person. I don't know that I don't know that I have a claim for defamation. You know, I mean, that's your opinion and you expressed it as such. Now, if you say Issa robbed a bank last week, now we're saying, hey, you made a false statement of fact. But then you might still say, well, listen, no one really, it's not something a reasonable person would have believed anyway. I mean, if you robbed a bank, it would have been in the news. So it was clear I was being facetious. You might have a very good defense there as well. Now, under the helm of defamation, there's a couple different causes of action that we commonly see. And I'm not going to go through the intro and statement of facts, which these are important elements of a lawsuit, but I just want to get to the meat and potatoes here. So there are a couple of important causes of action that fall under defamation. Slander and libel. Slander and libel. So in short, slander is when you engage in defamation based on what you verbally communicate. In general, libel is when you engage in defamation based on what you write. Now here we are in the internet age, so things that are published to the internet would be considered libel as well, though. So if you say something and then you publish it on Twitter or Facebook, right, that would be considered libel. The fact that you're saying it, though, it still would mean that it would be slander as well. So that's one distinction to look at. Another distinction that you want to look at is these differences between slander per se or libel per se and slander or libel by itself. So what that means is, what the distinction is if you have slander or libel per se, what it means is that the false statement of fact that was said, the contents of that, there's no question that it was defamatory in nature. Okay, so there are so many negative things you could say about somebody, and a court might have to make a decision about whether or not what was said actually qualifies as something that's defamatory. But courts have agreed that there are certain accusations that are always defamatory, right, or always slanderous or libelous in nature, controlling for those other elements that we discussed. So, for example, when you, as Tasha Kay did, when you accuse someone of being a prostitute, an adulteress, loathsome disease, if you say someone has, herpes, these kinds of claims, these are libelous or slanderous per se. So court doesn't have to examine them to see if they are actually defamatory. On the flip side of that is this, you see causes of action for, defamation per quad. And these are claims in which it's not clear from what was said. It's not a done deal that the statements that were made were defamatory. And you have to look at the context to kind of figure out, or maybe it was through implication. So that sort of thing as well. The per quad claims aren't really relevant here. We have this slander per se for count 1. We have plain old slander for count 2. We have libel per se for count 3. Count 4, we have intentional. Well, I'm sorry. Count 4 is actually invasion of privacy, false light. Now, invasion of privacy, false light. This is a cause of action. It's actually similar to defamation, I would say. And again, when I say defamation, think slander and or libel. But the fundamental difference between invasion of privacy, false light, and defamation is that invasion of privacy, false light, has more to do with misrepresenting aspects of a person's character and conduct versus defamation has to do more, has to do more with accusing them of specific acts. So the wrong is in defamation, we're looking at wrong that stems from the fact that you said something terrible about someone. In false light, it's more about a misrepresentation of their character in a more broader sense. So let's get to the elements. The first element would be that the plaintiff made, published a statement about plaintiff. He or she did it with reckless disregard for the truth. That so far it's pretty similar, right? Element 3 is that it placed the plaintiff in a false light. Element 4, it's highly offensive or embarrassing, and that's based on a reasonable person standard, as it often is in lawsuits. So you can't sue someone and say, "Well, I personally found it embarrassing for false light." No, the court would have to agree, or jury would have to agree that, well, the reasonable person would find this particular accusation embarrassing. There's no question that with the nature of the accusations here, that we're dealing with, highly offensive and highly embarrassing accusations. So there's definitely some overlap between those two concepts, but in general, that's the difference. One is a bit more specific and precise, I would argue, and the other is a little bit more abstract. That said, though, you'll find in lawsuits that a lot of times you're basically throwing the kitchen sink at them. So you'll grab any claim that could possibly fit. But here, false light is reasonable. I see it more in federal suits than I do in state suits. The fifth cause of action is intentional infliction of emotional distress. So when you're talking about intentional infliction of emotional distress, essentially what you're saying is that someone intentionally caused you harm emotionally and mentally. Now, not just that, right? But the nature of the conduct, it's extreme. So there are reasonable things that you can do to somebody that might make them go through all kinds of emotional trauma. Well, that's not enough, because under the intentional infliction of emotional distress cause of action, you have to act intentionally or recklessly. Your conduct has to be extreme and outrageous. Extreme or outrageous. And the conduct has to be the cause of, which is the third element, there has to be that causal relationship of severe emotional distress. Now, here again, highly plausible claim, right? The issue is, are making those kinds of accusations about somebody. First of all, did Tasha Kay act intentionally? Well, of course she did. I mean, it didn't appear that anyone was holding a weapon to her head or anything like that. Was the conduct extreme and outrageous? I think that might be some debate, but all in all, though, I would argue that the answer to that would be yes. To level those kinds of accusations against someone is extreme and outrageous. And did it cause emotional distress? Well, apparently Cardi B submitted information really showing that she was suicidal. She went through a lot of emotional trauma. She had to go to a therapist and what have you. And as long as she produced those records, or the court accepted her statements on those issues and affidavits on those issues, then the court accepts it. So all these claims in this case are actually reasonable. I mentioned kitchen sink earlier, but I don't think that applies here. I think they made claims that all made sense. The case went on for a few years. Cardi B got the W. Cardi B in this case was actually awarded over $4 million. So that's certainly a sizable judgment, and as we stated earlier, there are different kinds of damages that one might qualify for in different lawsuits. But in the case of Cardi B, the $4 million or over $4 million consisted of $1.25 million in actual damages and harm to her reputation. And let me clean that up a little bit. 1 million of that was actual damages and harmed her reputation. The other quarter of a million actually stemmed from the expenses for medical and what have you, therapy, all that sort of thing. The 1.5 of the plus 4 million, that was awarded because of punitive damages. So there we see the court awarding Cardi B more to punish LaTasha than they did in terms of what Cardi B, or what they determined Cardi B actually suffered in damages. That number was probably impacted by the fact that Tasha Kay wasn't just defaming her, she was doing so for reasons that were commercially advantageous to her, right? In the suit, they talk about how her viewership rarely exceeded 1 million, but on her Cardi B videos, you have several. Well, certainly there was one that was about 3 or 4 million views, and then we saw this sort of trend that that she kept going back to the well. So she did a total of 38 videos, they allege, against about Cardi B, got the viewership and benefited from it financially. Another factor, another award, and the damages, what brought it over the 4 million number, is 1.3 million in attorney fees. So Cardi B was awarded attorney fees. She paid over 1.3. Well, she accrued over 1.3 million in fees, and Tasha Kay is hit with that as well. So this is a really attorneys did a good job, and that's a really good judgment. And I really think she's sending a message out to the public and to content creators as well, that you really have to be careful what you say, how you say it, why you say it. These aren't issues that can sort of be trifled with carelessly. Now, naturally, when you're dealing with lawsuits and you get judgments, there's often scenarios in which these judgments are going to be appealed, and you can go on and on. So a lot of times what happens is you may get a judgment for 4 million, and then you may end up settling for a smaller number even after the fact. More or less it's a settlement, because you might figure, well, do I want to get 1.5 million now, or do I want to spend the next 7 years tied up in appeals or what have you? So a lot of people choose the prior over the latter. Here, though, there's something always to consider. I would venture to say that there's no way Tasha Kay can afford $4 million. Do I know that? I don't know that for a fact, but that would be my best guess. So in lawsuits, yeah, you can get big W's, but then it's a whole separate issue of how you're going to go about collecting. Can you collect? Can you get the money represented by that judgment? That's a separate issue, and that's a whole area of law too, dealing with post-judgment causes of action, and you're trying to garnish people and put liens on property and what have you. But anyway, that's a whole nother topic that we're not going to cover here, though. But for now, just talking about defamation, this is one of my sort of practice areas. I'm handling a case now for a public official that was very, very severely defamed. I'll probably do a separate video about that. Listen, like, comment, subscribe, give me feedback, and just as a reminder, I'm calling these off the dome. Look, I've got a lot going on, and I'm kind of a perfectionist, so I had to say off the dome to make it clear that, look, I'm grabbing these suits and I'm just kind of briefly reviewing them and just recording a video to discuss it, especially in my areas of interest. This was an area of interest that I was asked. It was certainly recommended that I talk about briefly, just because of the popularity. I have represented entertainers. As a matter of fact, I've represented one of the most legendary entertainers in American history. It was an amazing grace to represent her, a Motown legend. But anyway, that's that. If you have any questions, feel free to reach out. Email is the best way, help@iilawfirm.com. And obviously my website is iilawfirm.com. And again, this is Attorney Issa Israel, another edition of Off the Dome. Thank you for tuning in.